federal judge in Houston is deciding whether parts of a new Texas law banning all diversity, equity, and inclusion initiatives in Texas public schools is constitutional. On December 18th, the American Civil Liberties Union of Texas asked a federal judge for preliminary injunction on Senate Bill 12, a new state law that went into effect on September 1st and bans all DEI efforts in Texas public schools. In August, the ACLU of Texas filed a lawsuit to block the law from being enforced, arguing that it violates the First and 14th Amendments and the Equal Access Act. The bill prohibits employees from discussing gender identity with other staff or students, and it bans all student clubs based on sexual orientation in public schools, including gay-straight alliance groups. Now, the ACLU of Texas and students engaged in Advancing Texas are asking U.S. District Judge Charles Eskridge to block certain provisions in the bill, including the GSA club ban and the ban on discussion of LGBTQ+ identities in school, from taking effect while the initial lawsuit continues to make its way through court. In a news conference following the December 18th hearing, students and education advocates voiced their concerns over the new law.
We know that SB 12 is both unconstitutionally vague and far-reaching. It cuts off students' ability to ask teachers questions and receive information. School is far more than what is taught in the classroom. Throughout my education, school was a place for me to build community, to try new hobbies, and learn about the world from guest speakers and my peers. Censoring the richness that comes from school life, it is a disservice to everybody, harming students and their families who wish to learn from a multitude of perspectives, and educators who care deeply about the learning of their students alike.
The judge has not yet made a ruling on the injunction. Be sure to follow Courier Texas and subscribe to the TexEd Report as we continue to follow this case.